All right, are we started? Recording? Good afternoon, everyone. Welcome to our webinar, Navigating IP in 2026. My name is Andrea Reed. I'm of counsel with Lando Anastasi. With me today are my colleagues, Nicole Palmer and Nate Harris. Our goal for the next hour is to provide a strategic outlook for 2026 based on what we've learned from the PTO and the courts in 2025. So this webinar is being recorded for later viewing, and without further ado, I will turn it over to Nicole to get us started.
Thanks, Andrea. Well, we are witnessing an interesting period of transition at the Patent Office. I'm going to be touching on various USPTO updates, including pilot programs and other policy considerations. With respect to personnel at the Patent Office, we have a new director, John Squires, as confirmed back in September, and we'll be hearing more later on in the program regarding his initiatives. At the same time, we had the commissioners on both the patent and trademark sides step down early in 2025. So now we have acting commissioners in both of those roles. Likewise, there was an unsuccessful attempt to remove the current registrar of copyrights, which has opened up an interesting dialogue around the general appointment authority for such positions. Also last year, there was the federal mandate towards returning back to the office. The examiners were largely carved out from that initiative in view of their telework rights that are currently in place. But the PTAB judges are excluded from that and were required to return for hearings, etc. In September, as of September 2025, it was further announced that all PTAB hearings were going to be conducted in person. With respect to fees, at the turn of the calendar, there's always updates pertaining to agency fees. The USPTO had commissioned a third-party study with respect to its fee schedule. And unlike other agencies, the USPTO was largely insulated from the recent government shutdown. Nonetheless, we did have a new fee schedule go into effect last January, which brought some notable adjustments to the fee schedule that we operate under, including a couple of new fees, notably a tiered surcharge for continuation applications presenting older priority claims. So if you're claiming priority back to an application earliest benefit date going back 6 years or 9 years, there's a significant surcharge fee, $2,700 or $4,000 respectively. So that's a new fee with respect to continuation practice, which has been very, very notable with respect to larger patent families. There's also a new tiered fee structure pertaining to information disclosure statements submission, depending on the cumulative number of applicant-presented references cited. So 50 references, 100 references, 200 cumulative references. There's a tiered fee structure associated with that. Other notable fee increases, excess claim fees doubled. And with respect to design patents, the total cost of design applications through issuance is expected to increase by almost 50%. I wanted to touch on some USPTO infrastructure updates. There's definitely an increased emphasis on open data, data-driven quality control. We've seen the initiatives pertaining to enhanced assignment search functionality with a new assignment center, a new trademark center platform, and overall enhanced patent dashboards. Patent certificates, we saw an accelerated issuance of patent certificates. Effective May 13th, it was announced that the Patent Office was aiming for a 2-week window between issue notification and issue date. So from the applicant's perspective, that's great in terms of getting patents issued more quickly. It also helps control concerns around information disclosure practice with that general requirement. pertaining all the way through issuance of a patent. However, with respect to the strategy around potential continuing applications, whether it be divisionals or continuations, you need to strategize even earlier because you have much less of a window once you get your issue notification. As a reminder, since 2023, the Patent Office has been issuing patent certificates electronically, and at the end of 2025, they announced that the 1 millionth e-grant was issued. We're still seeing a lot of ceremonial patent certificates, paper versions being issued by the Patent Office on occasion, and of course that's available for a fee in case applicants would like to have a ceremonial copy. Lastly, with respect to infrastructure, the Patent Office has a network of regional offices and community outreach centers across the country, and they've solicited related stakeholder feedback about those locations and the services offered. I mentioned the cost of design patent applications, and just one other practice-related point, which is that the Patent Office has eliminated the availability for expedited Track 1 examination of design applications effective August of 2025. Apparently, they had seen a surge, almost 500% increase in related requests by applicants, largely believed to be fraudulent, and so they've eliminated that option. This brings us to other updates on various pilot programs. Track 1 is a very popular program for applicants, and the Patent Office recently further expanded the availability of Track 1 prioritized examination. They're going to be accepting up to 20,000 applications now, utility applications per year. Again, no longer available for designs. As a reminder, this allows for final disposition of applications within 12 months, as long as you have 30 total, no more than 30 total claims for independent claims. Don't take any extensions of time. It is expensive, $4,500 for large entities and $1,800 for small entities. It can be filed at the time of the initial application or with a request for continued examination. Patent prosecution highway, really nice for applicants that have received a favorable decision by an office of first filing elsewhere. The Patent Office is implementing a new approach that's going to docket these PPH applications based on pendency within the technology area. So looking at pendency of PPH applications against non-PPH applications, so that ideally, the pendency will be approximately half of that of non-PPH applications, but not wholly taken out of turn as previously. A couple of pilot programs that have been rescinded or terminated: the first-time filer expedited examination pilot program that was intended to increase accessibility by expediting the first office action for first-time filers. That was rescinded. The climate change mitigation pilot program, which was previously the green tech pilot program, that was also rescinded as of April. They're looking to dedicate resources to reducing pendency across all applications, regardless of technology area. And accelerated examination was terminated over the summer in connection with utility applications, but is still available for designs. It's generally considered undesirable and onerous for applicants because of the requirement to perform a detailed search and submit an examination support document. So Track 1 is still available for utility applications. And lastly, two new, relatively recent pilot programs: the Artificial Intelligence Search Automated Pilot Program, also known as ASAP, giving eligible applicants the chance to receive an AI-generated pre-exam search report listing the top potentially relevant prior art pieces before substantive examination begins, helping them assess and adjust their claims earlier in the process. Presumably, that would give rise to an information disclosure statement requirement. It's going to go through April for the time being and costs about $500 to participate. and another new offering, the Streamlined Claim Set Pilot Program, which is interesting if you're willing to have one independent claim and up to 16 total claims, you'll get faster examination for a relatively de minimis fee. The Patent Office is interested in seeing if the number of claims really has a significant impact on pendency and examination quality. I wanted to give a quick update on an important initiative before the Patent Office, that being patentable subject matter. We haven't seen a lot of guidance recently. Before I get to Section 101 per se, I just wanted to highlight an updated inventorship guidance for AI-assisted inventions that came out, just reaffirming for the purposes of U.S. patent prosecution that only natural persons, humans, instead of artificial intelligence, may be named as inventors on U.S. patents. There's no new standard with respect to inventorship. It's the traditional conception test with a focus on human contribution, artificial intelligence being characterized and explicitly treated as a tool. Regarding Section 101, we had an updated memo in August of 25 regarding subject matter eligibility. Again, we hadn't really heard from the Patent Office in this regard since July of 2024, where they had put out some other guidance with examples. This particular memo was directed to examiners in specific technology centers that handle software, AI, machine learning related inventions. Again, no new law established, simply applying the existing subject matter eligibility framework that's already in the MPEP, with an emphasis on looking at the claim as a whole and reaffirming the two-part Alice Mayo Step 2A framework. So the important inquiries being, does the claim recite a judicial exception, like an abstract idea, that being recitation as opposed to the claim having to be directed to? And if so, does the claim integrate that exception into a practical application? There's a lot of case law coming out of the district courts and federal circuit regarding patentable subject matter. Notably, this past year, we received a USPTO appeals review panel decision vacating a PTAB Section 101 rejection. This was the Ex parte Desjardins decision, cautioning against an overly broad application of Section 101. So this was very applicant friendly. An AI invention integrated an otherwise abstract idea into a practical application and was therefore patent subject matter eligible. What was probative here was improvements in how the AI model operated with respect to things such as reduced storage use, less complexity overall, maintained task performance. So these are the types of features that it could be very helpful to point to in prosecution of AI related patent applications. The MPEP was updated accordingly just in December 2025, heavily influenced by that particular decision. I think we're going to continue to see updates pertaining to the patentable subject matter debate. The Patent Eligibility Restoration Act was reintroduced in May federally, and that bill is aiming to reform Section 1, the language of the statute, Section 101, by replacing judge-made exceptions with clearer statutory categories. So we'll see what comes in the next year with respect to legislative activity. Other than Section 101, just a couple of other policy initiatives that the Patent Office is focused on. Fraud and Detection Mitigation Working Group. So the Patent Office is very concerned with security. Practitioners saw a number of new requirements with respect to security. There was a notice of proposed rulemaking that might require international applicants to be represented by registered U.S. Practitioners. This is already the case on the trademark side of the office, and I think has been seen as helping with respect to fraud. They're also looking to crack down on fraud. They're seeing a lot of issues pertaining to assertions of small and micro entity status. So that's definitely a big initiative. artificial intelligence, talked about it with respect to patentable subject matter, but definitely the agency and the administration continues to evaluate and put into place exploring AI strategies and policies. At the Patent Office, we're already seeing AI-assisted examination, especially of design patents. There's going to be some interesting developments with respect to the intersection of artificial intelligence and things like trade secrets and copyright. We'll hear a little bit about that. And then also, I think on the horizon is how are we going to regulate artificial intelligence? There's discussion of a one rule federal policy versus state level requirements. So that's going to be something that we're going to be looking at closely. PTAB reform, definitely ripe. We're 10 plus years post AIA. We're going to hear more from Andrea about the PTAB. But there's definitely a lot of interesting questions around things such as how are proceedings instituted? What are the underlying requirements with respect to real party and interest and pleadings? How should concurrent or prior adjudications be handled, especially in terms of claim construction? And with respect to legislation, the Prevail Act was reintroduced in May. So hopefully we might very well see some progress addressing those topics. Standard essential patents is an area that the Patent Office has expressed interest in revisiting. They recently formed a standard essentials patent working group and is also showing greater interest in international coordination. This signals a shift towards emphasizing strong, predictable remedies for SEP holders. Another policy statement that was actually put forward jointly with the Department of Justice and the Patent Office was submitted to the ITC, emphasizing that strong patents, strong patent remedies serve the public interest. So pro-patent stance. Incidentally, I think it made it to the mass media, but we heard the government even proposing floating the idea of a tax levy based on a percentage of a patent portfolio's value. So a lot of economic considerations. We're going to hear more about patents in connection with the larger drug pricing reform discussion. Notably on that front around drug pricing, the NIH put out a policy initiative statement suggesting that perhaps companies seeking commercial licenses to NIH-owned patents might have to include a detailed access plan describing how they will ensure equitable access. So that goes hand in hand with the pricing discussion. I thought I would just close with something fun and notable with respect to ex parte reexamination practice, which also was, I think, in the news. The Patent Office announced a very rare director-initiated reexamination of a Nintendo patent because of significant public outcry and the discovery of prior art. I'm wondering if we might see a little bit more of a resurgence of ex parte reexaminations, which have somewhat taken a back seat with the prevalence of IPR and post-grant proceedings before the PTAB. So that was definitely sort of something definitely notable. With that, I'll turn it over to Andrea on the litigation front.
And I thought I was turning it over to Nate on the trademark front.
Trademarks.
And I will jump in then.
Perfect.
Thank you guys. Thanks, Nicole. I had selected just a few trademark decisions to talk through here, some new procedures and trends that we're seeing at the USPTO on the trademark side of things. And then we'll discuss a copyright case from last year that involved AI, because of course you have to talk about AI in every webinar. So the first case we'll talk about, this is a federal circuit case, Bullshine Distillery. This is a case where this company Bullshine had applied to register the mark Bullshine Fireball for cinnamon flavored liquor. Sazerac brands opposed. They're the owners of the famous Fireball liquor here. You can see the bottle there. I've shown it in the context I'm most used to seeing it at a college dorm room. So Bullshine turned around. They asserted that Fireball was actually generic for this kind of liquor. There were drinks in the past that were known by this. So their view was because it was generic before, it's generic for all time. Whereas Cesarak argued that genericness is something that has to be evaluated at the time of registration. And so they put forward evidence that the mark was not generic through consumer recognition and whatnot around the time of registration. And so the board looked at that evidence and agreed the mark was not generic. And Bullshine then appealed that finding, saying that the later evidence should not have been given any weight. And actually, the relevant time period for determining genericness was a matter of first impression here. And so the Federal Circuit affirmed. Their reasoning, they looked at the statutory language. The statute prevents registration of a generic term. So arguably, registration, time of registration. They looked at the statutory purpose. Purpose is to protect consumers. And so all that matters is whether at the time the government puts its sort of stamp of approval, if you will, on the trademark, whether the mark is generic or not at that time. And then finally, they looked at the cancellation provision of the Lanham Act, Section 14, which allows cancellation at any time if a mark becomes generic. That shows that genericness is kind of an inquiry that changes over time. And so the takeaway here, genericness at the time of registration is really what matters. So next case is Plumrose. This is a precedential TTAB decision. Plumrose, well-known seller of meat and cold cuts in Venezuela, going back 70 years. Importantly, they have no sales in the US, but in Venezuela, they use that name, of course, in that logo that you see in the upper right there. And then along comes USA Ham, completely unrelated company in the US, as the name would imply. They applied to register that sort of black and white version of the logo underneath it. Clearly just a direct copy of Plumrose's branding. So Plumrose opposed the application on the ground that it was a misrepresentation as to source, but to file an opposition, you need to have standing, what they call it statutory entitlement at the TTAB, but it's standing. They needed to have standing to bring that proceeding. As I mentioned, they couldn't rely on any earlier use in the US. So what they did was alleged harm to their reputation in the US based on the reputation they established in Venezuela. People, as they do travel, people move from Venezuela to the United States, and they would be aware of Plumrose and its reputation. And USA Ham, was harming that reputation there. So evidence that they put in as to their reputation. Plumrose had received about 20 consumer inquiries over the years about availability of their products in the US. And the board felt like that showed people wouldn't be asking unless they'd seen USA Ham's offering and were possibly confused. There were also 5 examples of actual confusion. Actual confusion is huge evidence in a likelihood of confusion analysis. 5 is not a whole lot, but USA Ham sales were relatively small. So in this case, the board found like even 5 examples was significant. And then finally, of course, USA Ham's own decision to copy the branding suggests they knew of Plumrose's reputation and were trying to capitalize on it. So that is selfless evidence of Plumrose's reputation. And so the board agreed. They found that evidence persuasive. So based solely on, this company that never operated in the US, solely on their reputation in the US, it was found that they had standing. And then, once they cleared that hurdle, proving the misrepresentation of source was pretty straightforward. So the takeaway here is that reputation in the US alone can confer standing, even if the mark is not in use in the US. So the next case we'll talk about is the Dewberry case. This is a Supreme Court decision. Justice Kagan wrote this. It's a 9-0. decision as to the outcome. This plaintiff, Dewberry Engineers, won a $42 million award against Dewberry Group, and they sought and were awarded the disgorgement of defendants' profits, and that phrase is important here. The problem was that Dewberry Group made no profits. They had related companies that did have profits. They did have revenue. They had money in the bank, but as I said, Dewberry Group did not. And so the district court ruling on this, and as affirmed by the Fourth Circuit, they respected the corporate formalities. They didn't pierce the veil, so to speak, for the other company, but they noted things like Dewberry Group would not have existed. They couldn't have financially survived but for these other companies and the way the accounting was done. And so the court treated them as a single entity in awarding damages. So in other words, Dewberry Engineers could now recover from all of these related parties. And so the Supreme Court reversed. They pointed out the statute allows for recovery of a defendant's profits only, and these other companies were not named as defendants. So, nobody here argued for a piercing of the corporate veil, so that really was not considered by the court. There was a concurring opinion that pointed out there maybe were other provisions in the Lanham Act that could have allowed recovery from these other companies, what they call just sum provisions that would allow you to really look at the named defendants' actual gain, not their accounting profits, but how did they actually gain? But those arguments were not made here. So the takeaway here, as I say, is don't just sue that one broke defendant. Figure out, who needs to be named as a defendant in the case. Take discovery early, and make sure that you've got someone on the hook who will be paying the damages if you're lucky enough to win an award of them. Let's see. Next case is In Re Ye Mystic Crew, the Gasparilla case. This is a case. Gasparilla is an area down near Tampa, Florida. They have a big pirate festival every year. I guess it was just last week or so. Anyway, someone filed an application for the mark Gasparilla for glassware and shirts. They were refused over an existing registration for Gasparilla Treasures that covered a bunch of goods, including those same goods. So the parties reached a consent agreement, as people sometimes do in these situations. But the examining attorney refused the consent agreement. It wasn't accepted. And so the likelihood of confusion refusal was maintained. And so the applicant appealed. So what we're really looking at here is the 10th of the 13 DuPont factors, market interface. That's the one that covers consent agreements. I've got this bullet point here. Consent agreements can carry great weight, and I'd say they're, the majority of the time, vast majority of the time, they are accepted. The thought being parties kind of know their industry the best, but there's no guarantee it will be accepted. It has to have substance, and that's particularly true here, where the marks are very similar. The goods overlap, at least in part. So the board on appeal kind of looked at the agreement itself. It was very brief. Like I said, not a lot of substance to it. The parties said something like there isn't and will never be confusion. That's pretty conclusory. The parties appeared to operate in the same channels of trade. There were no restrictions on how the parties will use the marks to try to avoid confusion. It also looked at the amount of time they coexisted. If, and here it was only about a year. That's too short to look at and say, oh, these guys have coexisted for a while. There shouldn't be a problem going forward. Courts want to see, or the board would want to see more like, 5 to 10 years or more than that. 1 year is just not enough. So minimal weight was given to this agreement. And so the refusal was not overcome and it was affirmed. So takeaway here, and this is not news, this is just another example of the way this has kind of always been. You really need to provide detail in a trademark consent agreement as to how the parties are going to avoid confusion and or why you think they already are avoiding confusion. So So then the next case, Brunetti, this is a federal circuit case. In 2019, people will remember this case, the Supreme Court overturned the prohibitions on registering immoral or scandalous marks. Those were found to be impermissible viewpoint discrimination under the First Amendment. And that application in that case was brought by Eric Brunetti. And so he wanted to register a variation on the F word for a line of clothing. So now he's back here. He's filed a new application for the F word for a line of jewelry and phone cases. So he gets refused again, not because it's immoral or scandalous, because that's not an available ground of refusal, because the PTO is saying that word is not capable of acting as a source identifier. It's just a word that expresses well-recognized familiar sentiments, has a bunch of meanings. So Brunetti said, okay, well, what about the word love? You could say you could characterize that the same way. There's hundreds or dozens, however many, lots of registrations that involve the word love or comprise the word love. So the board kind of didn't really respond head on to that evidence or articulate a standard. It just said, well, we don't have a whole lot of context about those marks you're talking about. But you can bring forward other evidence of the source identifying function of your mark, but they didn't really say what they were looking for in terms of that evidence. So the refusal, was maintained. Brunetti appealed. Federal Circuit said, no, you need more of a standard. I know it when I see it is not enough here. And so it remanded the case for the board to articulate kind of a clear standard that applicants can rely on. So I think the takeaway here, or trend, or whatever you want to call it, is the PTO is still trying to find ways to refuse, what they consider offensive marks and things like that. So they can't call them immoral or scandalous anymore. They're going to try to say that it's not going to function as a trademark. So, it'll be interesting to see where this goes from here. Next up is game plan versus uninterrupted. This is another Federal Circuit case. This is a case where this nonprofit game plan owned a trademark registration for that non-handwritten mark in the upper right there, I'm more than an athlete. They had a priority date based on an intent to use application of 2016. So then uninterrupted IP, which is LeBron James's media company, in 2018, they also filed intent to use trademark applications. I think there were 6 of them for this handwritten version of this mark. So game plan opposed. Pretty clearly they had priority by about 2 years. So then after the opposition was started, LeBron went out and found an individual who had common law rights somehow or another in this mark. And he bought the common law rights with a written assignment. And along with it came some intent to use applications from that individual. That guy had been using the mark since about 2012, 2013. And he also brought that guy in as an advisor to the company. So now LeBron counterclaims and says, actually, I'm earlier than you guys. I have a 2013 priority date. So I've got you beat by about 3 years. So game plan didn't dispute this other guy's earlier rights. They disputed that the assignment was valid. First of all, they said it was an assignment in gross. It didn't assign the goodwill with the mark, so it was invalid. The court disagreed. They said, the board, and then as affirmed, they said the agreement had all the necessary language. It transferred the goodwill. And in fact, even that, bringing in that guy as a consultant for whether it was done for trademark purposes or not, that's considered, that would count as sort of a continuity of goodwill. Game plan also argued that this was essentially an amendment, a substantive amendment, which are not allowed to an application during an opposition proceeding. Federal Circuit disagreed. This is an assignment. An assignment is not an amendment. So they affirmed on that point. And game plan also did not really put in much evidence of their affirmative case. So at that point, it was sort of game over. So the Federal Circuit affirmed the cancellation of Game Plan's, the 2016 nonprofit cancellation of their registration based on LeBron's, rights that he acquired during the opposition that got him earlier by about 3 years. So the takeaway here is you can acquire earlier rights and assert them even when a TTAB proceeding is ongoing. And I was going to talk about some USPTO developments real quickly. There's some changes in how new applications are filed and the associated fees. These are worth considering, of course, as part of your filing strategy. So the PTO has done away with the T's plus, T's standard things people may be familiar with. Now they just have what this is called a base application. What it does, among other things, it really incentivizes you to use the pre-approved descriptions that the USPTO publishes in their manual. Unfortunately, the manual is a bit sparse, so sometimes things just don't fit. You can't find an entry that's going to suit you, and you have to write your own custom one. And the big change with the base applications is if you use all pre-approved entries that they've, like I said, that they've approved, the cost is going to be $350 per international class. But if you have to write your own entry, even one of them, then the cost is going to be $550 for every class. So in other words, if you have an application with 3 classes, you can rely on the pre-approved descriptions for 2 of them, but you need to write your own description for 1 class. The cost is going to be $550 times 3. So as you can see, the costs add up a bit quickly here. There's also a class fee now of $200 for every class that exceeds 1,000 characters. You see this a lot with European applications. For whatever reason, they write very long descriptions there. And so through priority claims and such, they make their way to the USPTO. I think this fee is an effort to really encourage people to trim those down. And then finally, there's a $100 per class fee for insufficient information at the time of filing. That would be things like if the application is unsigned, if you haven't translated a word from a foreign language, or if you don't provide a domicile address. And I just wanted a quick aside about domicile addresses. These are a huge sticking point for the PTO. A few years ago, they started requiring them. This is a physical address. If your mailing address is a PO box or something, you need to have a physical address. The purpose being there's a rule that if you're not based in the US as an applicant, you need to have US counsel. So that's how they figure that out. So the PTO really digs in on this point. They will they know all the corporate process server addresses in Delaware, PO box, that's easy, that's obvious. But like I said, they dig in deeper. They know, the address of every mailboxes, et cetera, in the country or something. They really investigate and they will refuse things. There's actually a case last year where someone, for whatever reason, didn't provide their domicile address, and it went to the TTAB and their application was finally refused. Let's see. Next, talk about pendency really quick. You can see here first action pendency, time since you file an application to when it's you got a first action, has been dropped considerably. It was at 8.5, 9 months a few years ago. Honestly, at times it felt like it was higher. It's now down to about 4.5, 5 months. I think that's due to a couple of things. What we just talked about with the new base application, forcing people to accept pre-written descriptions. That's probably streamlined examination a bit. The PTO has also cracked down on fraudulent applications quite a bit. They struck about 40,000 from the register in the last few years, actually last year. So that's probably cleared up the backlog a bit. And then on the right, you kind of see a competing story. This is the pendency of statements of use. The pendency now has gone up to, several months. I think it's 6 months. I can barely read my own slide here. But so that's caused some procedural problems because applicants, you file a statement of use, you can file a 6-month insurance request of time to fix your specimen if the statement of use isn't accepted. Well, as you can see, the pendency runs so long now that oftentimes the 6 months, the extension runs out before they've even examined it. So that's definitely caused some issues. If we could just go to the next slide then. Just two other quick updates. Some other fee adjustments. The statement of use, maybe because of that pendency we just talked about, the fee's gone up by $50 a class. And at the TTAB, opposition and cancellation deadlines, the deadline to answer has jumped. They've bumped it up from, you used to have 40 days, now you have 60 days to answer the complaint. And that's to bring us in line with our obligations under the Madrid Protocol. So I will jump now to my last slide here, the Bartz v. Anthropic case. This is a case out of the Northern District of California from last summer. This is really the first major case to deal with training LLMs using copyrighted materials. The case was brought by some authors against Anthropic's Claude AI. So Anthropic argued that training on the copyrighted materials was a fair use because it was transformative. The LLM training works by analyzing statistical relationships within the text and using that to generate wholly new text. And so the judge agreed and found this was spectacularly and quintessentially transformative. It doesn't replicate the books or supplant the need for them. It's creating something new. The judge said it turns a hard corner. And it's what they would say, it's analogous to format shifting. You're replacing a lawfully obtained physical copy. It's destroyed in the process. The binding is ripped off. The pages are scanned. And you're creating a digital one being used internally for the training. So that was allowed. However, they also were relying on a sort of a library they've accrued of pirated works, digital pirated works. That was not considered a fair use. That was disallowed, and Anthropic was actually found liable for infringement there. Even though it was transformative in that later step, that doesn't remedy the earlier piracy, the court said. And even, if they paid later on for the books, which I think there was some effort to do, that doesn't retroactively fix the piracy. So again, transformative, fair use, okay for the legally acquired physical books, not okay for the pirated books. So after this decision, the case settled. I don't know that's been finally approved yet, but anyway, Anthropic has agreed to pay about $3,000 for each pirated work. So yeah, I think I said the takeaway already, but training on legally acquired copies is okay. Training on pirated copies is not. So with that, I will turn it over to Andrea.
All right, great. Thanks. Thank you, Nicole and Nate. I'll be covering some litigation updates. The agenda for this portion, we'll go over the PTAB, some updates there, the Federal Circuit, some updates there, and then finally one update with the Supreme Court. So for those of you who haven't been following super closely, we have a new director at the PTAB. His name is John Squires. He was confirmed as the director in September of 2025. I lifted his picture from the PTO's website. I hope he doesn't mind. Background, he received strong bipartisan support in the Judiciary Committee and is largely described as being middle of the road in his core priorities. Some of what we can expect from him that he stated are his core priorities are born strong patents, and he uses that phrase to mean patents that are of improved quality at the time of issuance. And to do that, he plans on leaning more into AI at the office. He's voiced opposition to patent trolls, and he's seeking more transparency in foreign litigation funding. In general, people are considering this to be the start of a more pro-patent era, but I suppose that depends on your perspective. So one of the biggest changes we've seen since he became director in September are changes to the IPR institution process. So within a month, it was October 2025, he issued this open letter in which he assumed personal responsibility for IPR and PGR institution decisions. It was essentially ending delegation of it to the PTAB. His stated reason was a perception that the PTAB was incentivized to institute the AIA trials for quote unquote filling its own docket. Whether that's true or not, who knows, but he was concerned that there was that perception. And he cited extraordinarily high institution rates exceeding 95%. I don't know what time period the 95% was measured over, but regardless, that was his stated reasoning for needing to interfere in the IPR institution process as it had been going on in the past. So before this open letter came out, IPRs were a very popular and effective option for alleged infringers. They're faster, they're more cost effective, there's a lower burden of proof relative to what you would have in district court, and you get technically trained judges. Now, after these changes to the institution process, the PTO is reporting record low institution rates. So as of maybe a few weeks ago, I took that chart from the PTO's website. They were reporting about 37%. I've seen some numbers as low as 4%. And again, it all depends on what time period is being analyzed or measured against. But the point is that they're much lower than the 95% that the director had referenced in his open letter. And on top of the institution rates being lower, another thing that we're seeing are summary denials. And that's not something that practitioners are necessarily used to seeing. These summary denials, denying institution, there's no discussion of discretionary factors. There's no discussion of the petition merits. And it's really just a flat denial that's leaving the petitioners in the dark. So that's a change we've seen just over the past couple of months. And it's certainly something that's affecting the landscape. Looking ahead, there is a notice of proposed rulemaking. We're keeping an eye on this. This would further clamp down on IPRs. So IPRs would be unavailable if the petitioner intends to pursue invalidity challenges in district court. IPRs would be unavailable if the claims had been previously found not invalid by a district court anywhere. And there are exceptions for bad faith and the like, but in general, this would be a further clamp down on the IPR institution process. So the key takeaway on what's happened very quickly in the PTAB over the past couple of months is that patent challengers who are sued in district court, they have a new strategic reality they're going to have to think about in deciding which form they want to pursue their defense in. Moving on to the CAFC, but I guess still talking about the PTAB a little bit. I pulled out 3 decisions that the CAFC had issued this past year on the PTAB. I like to look for patterns in what the Federal Circuit is doing, and the pattern here is all finding no estoppel. So this is just a preview slide. The cases are Croy and Nicole, which I'm probably saying wrong, and Inland Diamond Products. All of these found no estoppel. So I'll go through each of them individually. Croy Holdings was an interesting one, in part because there was a petition for rehearing. It was ultimately denied. But I think the juxtaposition of the original opinion with the dissent and the denial for the petition for rehearing is interesting. So the first opinion, the one that stands, said that the IPR cannot collaterally stop a patentee from asserting other unadjudicated patent claims in a district court litigation. Okay, so that's fine. Then there was a petition for rehearing. And the dissent commented that commentators were concerned that this new, I guess, disparity, you could call it, could be evaded by having patentees withhold patentably indistinct claims from a district court proceeding until after the IPR is completed. So, whether that's held by, obviously the dissenting opinion in some commentators. So it's something to keep an eye out, looking forward to see how Croy is handled by the district courts. Let me see. And Nicole, which is the one I don't know how to pronounce, this was actually a matter of first impression. So the general rule is that IPR estoppel applies to 102 or 103 arguments in district court if they're based on patents or described in a printed publication. So the matter of first impression here in this case was how to deal with patents or printed publications evidencing device art, which if something is known or used by others, if it's on sale, if it's in public use, general rule, that's fair game in a district court, even after an IPR. And the court held here that patents and printed publications evidencing device art, that's not subject to IPR estoppel. So that can be used as evidence of a ground. It just can't be used as the ground itself. And the last case I have up here showing no estoppel on PTAB matters is Inland Diamond Products. So the key takeaway from this case is just that the PTAB's factual findings in an IPR are not automatically going to bind the district court. And that's just a function of the different the standards of proof. So the board might make a fact finding under the preponderance of evidence standard, but the district court has a higher standard. They're not going to be bound by that. It may very well be that the facts found under the lower standard are sufficient to meet the higher standard. But the point is the Federal Circuit is saying you can't just take that automatically. It has to be found on its own. So that is the takeaway from Inland Diamond. And now moving away from the CAFC on the PTAB, we're going to look at CAFC opinions on district court matters. So a big one here is damages. There were a lot of Federal Circuit cases this past year on damages, and again, in the nature of looking for patterns, there is a continued scrutiny of damage opinions coming out of the Federal Circuit. In general, the most interesting thing about this is that it doesn't matter how big or small the damage awards are, whether the damages are being reduced by 2.6 million, which was the case in Wash World, or whether it's vacating a lump sum damage award of 300 million, which was the case in Optus Cellular, the second case on the slide there. The Federal Circuit is treating them all the same way. So there's scrutiny of regardless of who the plaintiff or defendant is and what the award is. So the first one, Wash World, that's a bit out of the following cases all pertain to licensing agreements, but Wash World concerned convoy sales, and the later ones, let me see, Optus concerns license agreements. Oh, sorry. Eco Factor, this is an important case. Let me see, if you only remember one damages case, it should be Eco Factor. This one had 21 amicus briefs, and the Federal Circuit in this one said that an expert opinion was unreliable because a lump sum license was used to determine a running royalty license. And essentially there was a mismatch there. So the lump sum license can't be used to determine a running royalty license. The dissenting opinion. And then two more on CAFC damages continued scrutiny cases. We have Super Lighting and Rex Medical. Both of these were vacating jury awards. Let me see. So these are when there's a mismatch again. So we have allocating licensing fees and apportioning fees, and they're just not being done the same way. And Marna being the exception, not the rule. Okay, so this is on DOE. DOE is, let me say, again, looking for patterns. DOE, the Federal Circuit had 4 or 5 cases on it. In all of these, it was found to be the exception and not the rule. Let me see. A few more cases coming out of the CAFC. These aren't necessarily patterns per se, but there was one case on willfulness. It's Wonderland. This is a good one to read if you're interested in seeing an example email of what the Federal Circuit would find is, I guess it would be relevant evidence of willfulness. Also a case, Google v. Sonos, that was widely watched. It surprised a lot when it came out as an unreported opinion. But that one affirmed that it's not improper for an applicant to broaden his claims during prosecution in order to encompass a competitor's products. And then finally, a case on equitable estoppel. This one was interesting because it held that silence as well could constitute misleading conduct. All right, and then just to close, we have one case from the Supreme Court. So after what some have called a patent drought for 3 years, the Supreme Court's granted certiorari in Ameren v. Hickman. So this is a late-breaking development, just came out last month. It might be easy to say, I'm not going to pay attention to that case. It's pharma. My company's not pharma. It's actually not. It might not, I should say, be a pharma case. So interestingly, the Federal Circuit had said this appeal is not a Hatch-Waxman case. It's not a traditional ANDA case. It's not a Section 8 case. the Federal Circuit said it is nothing more than a run-of-the-mill induced infringement case. So for that reason, depending on how narrowly or broadly the Supreme Court considers the issue and wants to speak to it, we might have an opinion that pertains to more than just pharmaceutical companies. So the procedural posture in this case, it was a motion to dismiss under 12b-6. The CAFC ultimately found that Amarin plausibly pleaded induced infringement. And I think that's part of the procedural posture of this is part of how it came out, right? Because it's not a question of was there in fact induced infringement. It was just whether it was plausibly pleaded. But it pertained to Hikma's generic version of Amarin's Vascepa. So Hikma had obtained FDA approval for one indication, and it carved out the patented indication. This is what we call a skinny label. That's all fine. And then here's where it gets interesting. Hikma's press releases referred to its drug as quote unquote generic Vascepa. And it also referenced Vascepa sales, the sales data that included the carved out indication. So I think it was 75% of Vascepa sales data was for the carved out indication, and Hikma was referencing all of that. And again, it's supposed to be operating under a skinny label. So the issue before the Supreme Court, it's not necessarily whether the generic manufacturer is using a skinny label appropriately, but it's also with respect to its public statements in marketing. So I would say that even non-pharmaceuticals, anyone who's having public statements in marketing should probably pay attention to this case. So right now, that's the only one before the Supreme Court, but we'll be keeping an eye on that as well. So that's it from me. If anyone has any questions or wants to reach out to any of us, please do. Thank you for hanging in there, and we'll see you next time.